expecting you to have a nice slide, nice dialogue that we can have as we go through this lesson. Um, so the point here is that it should be a chat. It should be a conversation. So if you feel like there is anything that you would want to clarify before, as I talk about certain things, these will be very relatable stuff that I'll be talking about. So if there's anything that you feel like you don't understand, you want to talk about, you have an experience you want to share, please stop, share, because that's the whole point of all of this, right? Because Dr. Cabral would have mentioned to you, exams are not going to be that difficult. The business law module exams have never been difficult. We have never set difficult papers. We don't. Our objective here is not to fail you and to give you hard papers. Our objective is to give you a very easy paper for you to be able to do it very easily. But the idea is that you listen to what we talk about at lectures and understand something and take something away from it, because you all are in various different fields, right? So the construction field, if you're an accountant, now I'll be talking about things like professional responsibility and professional liability. Now, those are very important things for you to know as a construction person involved in the construction field, as an accountant. You're liable for what you say and what you do. So these are things that will have practical implications in your life. So if you pay attention to what's going on to these lessons, they'll definitely have some practical implications. So Dr. Cabral, as I understand it, did an introduction with you, did company law with you, and did IP law with you, correct?
Yes, correct.
Yeah. Okay, so my job is then to cover with you contract law, which I will start today and we'll finish off tomorrow. Contract law will be a 2-week session because I don't want to overburden you with a lot of stuff, right? Because I personally think that these lectures being for 3 hours is also a little too long. Students' learning capacity and listening capacity is also limited, especially on Zoom. You can only pay attention for so long, right? I used to teach for an LLB program, and when we had the COVID pandemic, we reduced our lecture time to 1.5 hours online because people can't keep their attention, cannot be held for that long. So I'm not going to go on for lengthy hours, for hours and hours. I'll try to keep it as short as possible. I'll give you a little break in the middle to take like a break from the screen, take a little breather and come back. But roughly about 2 hours, we'll try and cover what we have to cover today. So contract law will be covered within today and next week, not today and tomorrow. Then next week, I will do tort law or DLIC law, and then IT law, right? Then the week after, we will do arbitration law, or we may change these around, but I'm just telling you the topics: contract law, DLIC law, IT laws, arbitration, right? And finally, 1 week we will dedicate towards answering any questions you all have finally, and to do the group presentations, right? So what I'll do is I will release to you the cases for the group presentation maybe tomorrow, which will give you 3 weeks to prepare, right? So since it's only 3 groups, we can give you all about 20 plus minutes to do a presentation, 20-25 minutes if you want, right? So everybody can present and spend a little time, right? So you can do a presentation. It will be on one of the cases. I'll give you all 3 different cases. Let's say one from company law, one from IP law, one from contract law. Yeah, so we'll cover those 3 cases. And it'll be very easy cases. It won't be difficult cases to find material on. So you can do a presentation on it with your group. It will be on the last lecture day. I think 3 weeks from now, Saturday is the last lecture. On that day, we will have the presentation. Yeah, I haven't thought about what cases to give. So tomorrow I will give you the cases. Okay, is that okay? Before we start the lesson, I just want to talk a little bit about the exam, because I know that's a big component for you, big factor for you. I don't know if Dr. Cabral spent much time talking about it. He generally doesn't.
No.
Right? No. He doesn't. Let me have a little chat about it with you, because I think that's a very important part to students. They consider that a very important part. So there are 3 components. 20 marks will be allocated for your group presentation, right? Group presentation will be a case study. That case study is expected to cover the facts of the case, the judgment, and the impact of that case. Those are the 3 main things. You can talk about anything other than that. Anything beyond that is completely fine. But what I am looking for is, are you covering the facts? Are you covering the judgment? Are you covering the impact? Because all these cases will have significant impact to the area of law going forward. These are landmark judgments, what we call landmark judgments. They change the entire way that the law is seen. So what's the impact? So those are the three major areas that I want you to cover. Right? Don't worry, we don't mark very harshly on it. If you do a decent presentation where you cover these three bases, you will get your marks, your 20 marks, right? Then you get 30 marks allocated for your individual assignment, which you can now already probably have started to work on. Is the deadline the 15th of June? Is that what it is? Or when is the deadline for it? 15th of June, yes. 15th of June. So you have 15 days. Dr. Cabral has already covered that topic with you. Director's duties is the topic that you need to cover. So the word count is roughly about 2,500 words. You don't have to, there's no limitation. If you want to write more, it's completely fine. But let's say a minimum is about 2,500 words, give or take 10%. You can go lower than 10%, about 10% less is okay. I'm not going to count the words, basically what I'm trying to say, but roughly we're looking at about 2,500 words. Yeah. So this, now I'll tell you the teething problems we've had with students when they write their individual assignment. Because it's a legal assignment, which covers mostly the same sections, plagiarism becomes very high. The plagiarism count becomes very high on on Blackboard. When you upload it, it'll say there's a high plagiarism count. So ways to avoid it. Look, we will give you a little more leeway than other subjects do. Other subjects, what is it, 30% that your plagiarism you allow? 30%? Yeah. So maybe for legal, we will give you like 40%, right? What I want you to do is not to rewrite the sections of law. That's why mostly it becomes a problem. If every student writes the section over and over again, then it gets caught in plagiarism, right? So my recommendation is read the sections and analyze the sections in your own words. Don't try to write the section again, because to be very honest, I know the section. I don't need someone to tell me what the section is. What I want to know is, have you understood the section? So rewriting the section, I'm not going to give you any marks even if you do rewrite it. So you analyze it. Tell me, what does the section say? Why does it say it? So if you wanted to, then you could look at Vikram Veerasuriya's book and find case law on it, right? Case law that you can cite on it. You can do enough and more research online. There's lots of cases that you can find online, right? That's up to you. How you kind of find good material is up to you. But the basic is to analyze the sections of law, right? So I would have talked about 187 onwards. What are the sections that you need to know for director's duties? We would have talked to you about, right? The other big problem that we have with the individual assignment is that students sometimes get ChatGPT or AI to write their assignments. Now, say this because this has been a problem, right? And how do I know it? Because when you upload it to Blackboard, when I go to mark it on Blackboard, Blackboard tells me there is a 75% probability that 75% of this has been written by AI. 100% of this has been written by AI. So Blackboard has its own AI, which tells you whether that has been written by AI or not. Okay, so you may use AI to write your essay, but the AI will also tell me that this is written by AI. Look, I'm not for a moment, I'm not one of those people who believe that AI should be completely banned. No, I think AI should be used. You should use AI. But use it for inspiration, use it for fact finding, use it for, expanding knowledge base. Don't get it to write your assignment, but ask it certain questions that will help you carve out an answer. So about 20-25% of AI use in an answer, we will generally tolerate. The problem becomes when you do 100% is AI written. That is the problem. 75% is AI written. I can't give a pass mark for that. Right? So use AI like a tool. Don't get AI to do all the work for you. but use it as a tool to help you write your answers. That's completely fine. Okay. So these are little pitfalls that students have fallen into that I'm telling you don't fall into, because unfortunately later on we get emails saying, oh, I wrote such a great essay, but I didn't get a pass mark. Why didn't I get a pass? Right? Because your essay was written by AI. Couldn't give a pass mark. Right? So, so rather than send me emails later, don't use AI to write your assignment. Do it by yourself. Right? I know it sounds very obvious when I say it like this, but last year itself, I had about 10 assignments written 100% by AI. Right? About 10 out of the, I mean, small percentage, about 300 essays I looked at. Out of that, about 10, 100% were written by AI. Okay, so let's avoid that. Okay. And finally, we have the final exam, which is a 50-mark paper. Guys, we will give you 5 questions. You have to answer all 5 questions. But what I will do, and what Dr. Cabral usually does, is that on the last lecture day, we will discuss the areas that we are hoping to cover for the exam. What the questions are going to be, where are they going to come from, right? In contract law, this part is where we're going to ask you a question on. We'll tell you, right? So that way you can hone in your studying to that particular area, right? So there won't be any surprises at the exam, right? It won't be a surprise. You can, easily write the answer, no problem. How is your exam going to be conducted? Is it a physical exam or is online exam, right?
Online.
So it's an open book online exam, so you can use all the material that you have and write your exam. That's completely fine. But we will tell you, okay, these are the areas that we're going to potentially question you. Dr. Cabral, sometimes if he's online, he may even tell you exactly what the question is. He's like that, right? He will tell you what the exact question is also before the exam, right? But at least, if nothing else, I'll tell you what areas we're going to ask the questions on. Okay? Any questions or any thoughts on this whole exam and how it's going to be structured? Any thoughts that you all have you all want to share?
No, regarding
It's
this
understood.
presentation, group presentation.
Yeah.
Now it's a group. I mean, we have 4 members in our group. So our 4 members has to deliver the presentation minimum 20 minutes, or individual has to deliver separate. It's not like that.
No. Together, right? Combined, it has to be 20 minutes. 20 so you all can break it down. Everybody can speak 5 minutes each. Everybody covers 2 slides, 3 slides. That's fine. It's up to you.
The time was not decided, right? It says that 15, but the time did we? I mean, it's already confirmed the time. What time are we going to deliver this presentation? No.
So it will be the last week of your lectures. When is the last week of your lectures? Last Saturday.
Last week, in the sense 16th.
16th or 15th, no? Your last lecture is on the 15th.
Sorry, yeah, 15th, yeah.
15th, yeah. 15th, we can have the presentation.
Any time period? I mean, any specific
class time, no?
Like what time? Class time? During class time? 4:30?
During class time. During lecture time. During lecture time. Yeah, during lecture time. No, we won't take you out of it. So basically, as we start at 6, we can start the presentations at 6 itself. Yeah. Is that okay? One other thing about presentations, I don't know if you all will do this, but some people, when they do presentations, they put everything they're saying on the presentation, on the slide. The text, so much text on it that we can't, as the audience, listen to you and read the text. It's too much.
We had one presentation. We did business communication. So from that, we learned what exactly need to do now.
Right. Okay. Perfect. So you all know. So my recommendation is just a few buzzwords should be on the slide. You should be talking. Yeah. That's the object here, right? Yeah. Because I've had presentations where there are about the text is so small and so many lines of text. You can't understand a word. So avoid those little things. So these are things that you learn. These are the things that you learn. So avoid those. Any other
Under
issue? Yeah.
under business communication, they teach us very well how to do the presentation and they guide us
Nice.
very well. Yeah.
That's good. That's great. Okay.
We did a
Anything
25-minute presentation there.
Right. Okay. So you all are experts on making presentations then. Perfect. Great.
Now
I'm
we have
expecting very high
idea.
level of presentation then, huh?
When will be the exam?
22nd.
Second.
Okay,
Come on,
22nd
look at the
of January.
timetable, gentlemen.
It is their timetable.
Yeah, look at the course.
22nd, is it?
that
I don't know. I
as per
don't
that
know when the exam
time
is.
22nd, sir.
22nd. Okay, right. Okay, perfect. Okay. Anything else? Any other thoughts? Any comments? Anything that you want to get off your chest regarding exams? Because look, we have to talk, right? This is the only way we get everything out. It's my way of teaching is very similar to Dr. Kabra's way of teaching, where you would have seen how he teaches. No, it's a conversation, right? It is not never meant to be where I just talk for 3 hours and call it a day. Not
Correct.
okay. All right. So we start then on contract law today. Okay. So contract law is an interesting area. Also, do you all have access to the notes for the lessons? Has lesson notes been uploaded to Prajna for you guys?
No,
Yes.
not until when
Lesson.
because I checked. We have the
as in
textbook.
we don't
for
have
every
textbook.
topic. Is there
That's
for
textbook
no,
notes,
no,
right?
not the textbook.
There are no lessons
like
notes. Lessons not uploaded.
lesson notes.
Not uploaded.
Okay.
Not
Not
uploaded.
uploaded.
All right. Okay. So we have, rather, I have prepared based on the lectures the basic skeleton of what are the major topics and what we're talking about. I'll get that uploaded to Prajna over the next couple of days. Who's on? Who's the PIM admin today? Who's doing this? Is it Jude? Jude? Who's on the PIM side today? Never mind. I'll email Mr. Ranapura and I'll get it uploaded onto Prajna over the course of the day today. So you will have all the notes tomorrow. Yeah?
Thank you.
Sorry about that if you don't already have it.
Yeah, perfect.
Right. So contract law. Let's talk about contract law for a little bit. Everybody enters into contracts. Everybody has entered into contracts, right?
Yes.
So what is a contract? Can anybody tell me what is a contract? I'm not asking for a legal definition. I'm asking you, what is a contract? Can anybody tell me what a contract is?
About agreement between two parties?
It's an agreement, not necessarily two parties, multiple parties.
Two or more parties.
Yeah, more parties also. Yeah, okay. Agreement between two or more parties. Okay, good. It's a good. So I'll try and do contract law, explain contract law in 10 points. If you were to take a piece of paper and write it down, I'll explain contract law basically using 10 points. Okay. The first point is the definition of contract, right? What is a contract? Contract, like you said, is an agreement between two or more parties. Is there something more to it?
Yeah,
Yes.
agreement to
which is
deliver
legally enforceable.
That's correct. That's very important. Because not all agreements are legally enforceable.
Yeah.
So a contract essentially is an agreement between multiple parties which is legally enforceable. That's a definition, right? The best lawyer in town will still define contract law that way, right? It's an agreement between parties which is enforceable by the law. Because there are some agreements that cannot be enforced by law. Now, as we talk about this definition, you also have to understand in Sri Lanka, and since you are learning this from the vantage point of Sri Lankan law, right? Contract law in Sri Lanka is governed by two types of areas of law. That is Roman Dutch law and English law. Both their influence is seen in contract law. Dr. Cabral would have covered that a bit with you, know, right?
Yes, he did.
Yeah. So the influence of Roman Dutch law and English law can be seen in creating this definition of contract. When we say something is a contract, the definition given to a contract, the definition comes from Roman Dutch law and English law as well. Okay, that's the first point. Simple, very, very simple point. Second point is, now let's talk about what constitutes an agreement. And what is an agreement?
Offer.
Yeah.
Offer.
Tell me.
Offers.
Offer. Offer is an agreement.
Acceptance.
Yes. Okay, very good. You've done your homework. Very good. All right. Offer and acceptance.
Rules and regulations. Intention.
Rules and regulations. Yes, it is rules and regulations. The terms, yes.
Intention.
Sorry?
Intention.
I didn't hear the last bit. Intention, okay. Intention, okay, that's also fine. Yeah. So an agreement has all these components, offer and acceptance. Those are the technicalities that we will get into. But before that, let's talk about two different types of agreements that we have in society. There are domestic agreements and commercial agreements. Domestic agreement is an agreement that you have with your spouse, right? You have agreements with your spouse all the time.
Yeah,
No?
that's a big one.
Yeah, you do know, right? You have an agreement when you're about to go out from the house. Your wife tells you, when you're coming home today, pick up some groceries. And you say, okay, I'll pick up the groceries. That's an agreement. Now, when you come home without picking up the groceries, you have breached that agreement. But the question is, can you be sued for it?
No.
No.
That's the key, right? So another similar type, that kind of agreement is agreements you enter into with children. Now, with your children, you come to agreements. So you will tell your child, you pass your exams, I'll buy you a new smartphone. Right? It's an agreement. When the kid passes the exam, they can't say, give me my smartphone. Where is my new iPhone? And when you say, no, nothing doing, they can't take you to court. Why can't they do it? Because it's a domestic agreement. Domestic agreements have this presumption built into it. There is a presumption built into domestic agreements. In law, we call it a presumption. The presumption is that domestic agreements were not meant to be legally binding. That's a presumption. That doesn't mean that the domestic agreement can never be legally binding. Domestic agreements can be legally binding sometimes. But you have to go out of your way to show that you intended to be taken seriously, that you and your spouse, that agreement that you entered into, you wanted it to be taken seriously. You get what I'm saying? You understand what a presumption is. A presumption is that we assume something. But that doesn't mean that assumption will always stand. Sometimes we can disprove it. So the presumption here with a domestic agreement is that we were not intended to take it serious.
Now, in case of prenup, the prenup you call it. So that's a domestic agreement, but presumed to be legally binding as well.
Absolutely, a perfect example. Sorry, your name is Chaminda, no?
Mine is Chaminda, yes. Yeah.
Yes, perfect example, Chaminda. A prenup is a domestic agreement between two partners, which is intended to be taken seriously because they took steps to make sure that they are taken seriously.
Right.
right? I'll give you a case called Balfour versus Balfour. All these cases that I'm mentioning will be in that short note that I'm going to provide for you, okay? Balfour versus Balfour, BALFOUR versus Balfour. BALFOUR, Balfour. Balfour versus Balfour. Balfour versus Balfour is a case where it was between a husband and a wife. That's why it's Balfour versus Balfour. Mr. Balfour and Mrs. Balfour. Right? What happened was Mr. Balfour was stationed to come and work in Ceylon at the time, during the British time. This was a couple living in England. Mr. Balfour was stationed in Ceylon. So he left the wife in England and he came and settled down or he started working here in Sri Lanka. Now, before he left, they came to an agreement. What was the agreement? That Mr. Balfour will send Mrs. Balfour £30 a month for her expenses. £30, a lot of money at that time. That £30 a month would be sent by Mr. Balfour to Mrs. Balfour for her maintenance. Okay? A few months into living in Sri Lanka, he decided, I don't want to pay my wife. Now, why that is, we don't know, right? But he decided, no, I'm not paying my wife anymore. Mrs. Balfour said, that's a breach of a contract. We have an agreement, you have breached that agreement. She went to court. The court said, this is a purely domestic agreement. This is purely a domestic agreement, and you all haven't done anything to suggest that this was meant to be taken seriously. If they had done something to make it so that it's taken seriously, then it's a different story. Then it becomes binding. But if you don't, then the law will say this is not binding in law.
Sorry to interrupt.
Yeah, go ahead.
If we paid continuous maybe 1 year, like the 40-40, 1 year, that is not the case. They cannot put.
No, just because you paid for 1 year doesn't mean that there's a legally binding agreement. No.
But if it says that if you not do so, then the consequence will be so and so, like that, in a, like agreement in that.
Yeah. So then, if you had put in terms like that, if you had put it in writing, if you had gone to a lawyer and drafted a contract and got it signed between the parties, then that is very clearly showing that although we are husband and wife and although this is a domestic agreement, we want to be taken seriously. But the fact is here, this was just a conversation the two of them had before Mr. Balfour left England. In their living room, they had a conversation. That was it. Where Mr. Balfour said, I'll send you £30 a month. Court said that agreement is not legally binding because it was a domestic agreement.
Which means there's no proof, evidence that signed by both parties agreed to deliver like that. It's because of only just...
There was no evidence to prove that the parties wanted to be taken seriously, Ramaji. Now, say for example, a prenup is a good example of you being wanting to be taken seriously. Right? Now, when you're in love and about to get married, you will say, whatever belongs to me, whatever is mine is yours. Right? You say these things. Those are not binding. But if you sign a prenup, that's very clear indication, look, we want to be taken seriously. This is a serious contract. Even though it's between two partners, this is a very serious conversation. This is a serious contract. Right? Do you follow that logic? So yes, domestic agreements, the presumption is it was not meant to be taken seriously. But of course, you can disprove it and bring evidence to say, no, we meant to be taken serious. We meant to be taken serious. Okay. Now, with commercial agreements, the exact opposite presumption exists. If it's a commercial agreement between commercial parties, then the presumption is that the parties intended to be taken seriously. always intended to be taken seriously. So if you, working for your company, you call up a supplier and negotiate something with them, right? Then even though it was an informal conversation on the phone and you entered into an agreement, you can argue that you meant it was meant to be taken serious. Commercial agreements, the presumption is you meant to be taken, you intended to be taken serious. But again, you can disprove it. You can say, no, although this is a commercial agreement, we didn't want to be taken serious. Commercial agreement is entered into in, a situation, you can say, no, we didn't want to be taken serious. You can prove it. But the presumption will be, if it's a commercial agreement, the party is intended to be taken serious. Is that clear?
Yes.
Yeah.
Even it is a conversation between parties.
Correct. If it's a commercial transaction, it's a commercial agreement, then the presumption is you were meant to be taken serious. So when you negotiate, when you talk to people in your professional capacity, you have to understand that you might be entering into a contract, you might be entering into an agreement, even though you think you're having an informal conversation. If you are having an informal conversation, you have to make it very crystal clear that this is an informal conversation. Right? When you're having with a commercial party, you have a conversation, you tell them, look, this is off the record. This is off the books. This conversation is not a serious conversation. We are just having a chat. You have to say that. You have to very clearly establish those ground rules. If you don't establish the ground rules, then problem. Right? Okay?
Yeah.
Right. Now, then, so the first thing is you have to have an agreement that can be legally binding, which is usually a commercial agreement or a domestic agreement, which was meant to be taken serious. Secondly, there must be 2 or more people, right? 2 or more people must come into this agreement. Thirdly, there must be an offer made. There must be an offer and acceptance. Now, somebody mentioned this offer and acceptance must be there. First is there must be a valid offer. What is a valid offer? An offer is a very clear indication that you want to be taken, that you are offering to enter into a contract. Right? That there are very clear indication on one party saying you want to be bound with another party on a contract. That you want to enter into a contract with another party. You have very serious intention. You have to show that intention. For example, if I come up to you and I tell you, do you want to buy my phone for $500? Right? Do you want to buy I want to sell you my phone for $500. Very clearly, I want to sell it to you. I'm very clearly wanting to be bound by that conversation. But then you've seen people write on Facebook, my phone is for sale. If you are interested, DM me. Right?
Correct.
Now, do you think that's an offer?
No, it is not. It
is not an offer. Why? Because it doesn't have that intention to be bound. So just because you DM that person is under no obligation to sell you the phone.
Correct.
Offer must be a very clear intention to enter into a contract. So offer must have several characteristics. One, the offer can be made expressly or impliedly. Expressly, impliedly, or by conduct, you can make an offer. We'll come to that in a minute, right? The offer can be made to a single person, a group of people, or the entire world at large. You can make the offer to the entire world. You can make the offer to a group. I can make the offer to I can make an offer to sell my car to anyone from the PIM Oman batch of 2024. Putting it out to anyone. I tell you, look, I want to sell you my car for X amount. Anybody who is interested, tell me. Right? So I'm making the offer to all of you. Or I can make an offer to one individual person. Okay? So there must be a clear offer. We have to differentiate an offer from what is called an invitation to treat. Offer must be distinguished from an invitation to treat.
Invitation to treat, T-R-E-A-T.
Treat, yes. Treat,
All right.
T-R-E-A-T. Treat. Invitation to treat. Now, I'll ask you a question. Now, everybody is going to a supermarket. No. You go to the supermarket. You pick up a cart. You go down the aisles, right? You pick up so on the shelves, there are goods marked with certain prices, price tags all on it. They are marked. You pick up these items, put it on your cart. Correct? With me up to this
Very
point?
correct. Yeah. Yes.
Then
yes.
you go to the cashier and you put it in front of the cashier. The cashier bills you. Now, where in this entire process of you being at the supermarket was the offer made? And who made the offer? Can somebody tell me? Who made the offer? When was the offer made?
The offer was made at the racks where the price is clearly marked with the product.
Price is clearly marked. Okay. Anybody else? Any other thoughts?
That's the invitation to treat.
What is the invitation to treat? The prices marked on the shelves. Okay. All right. Okay. That's a good answer also. Okay.
When he is moving to cashier and
Okay.
the cashier bills, the agreement made.
That's the offer. So who is making the offer then? In your
Cashier.
situation, who's making the offer?
Cashier.
Cashier is making the offer and you are accepting. Is it?
Yeah.
Because offer and acceptance will come to in a minute. So the cashier is making the offer. Now in Chaminder's situation, Chaminda is saying the items on the rack is the offer. So that means the supermarket is the one making the offer.
This is what I thought.
Yes.
Oh yeah, okay. Yeah, it's good. Just trying to understand. Anybody else got any other thoughts? Well, we do
Now,
this, no? We
now
go to the
sometimes
supermarket.
here-
Everybody goes to the
here now-
supermarket. Yeah.
Confused
Here
now.
in Saudi Arabia,
Yeah.
generally the big days people do groceries is Friday and Saturday.
Yeah.
And every Thursday night, you get a printed paper coming to you from the supermarkets.
Yeah.
It's been basically thrown at your car, kept under your door, hang everywhere where
Okay.
you can see. And that one clearly indicates the prices for that weekend with what are the discount items and all that. In that case, I would even say that if I go
That
to
is
the
the offer.
supermarket, if I go to the supermarket with this paper, and if the prices are different, then I think I can demand. So I can consider the leaflet as the offer.
Okay. All right. These are valid points. Yeah. Okay. Anybody else? Any other thoughts? No. Okay. The offer is made by you, the customer, right? When you go to the supermarket, pick up the items from the shelf, put it into your basket, nothing has happened. You go to the cashier and give the item to the cashier to bill. At that moment, you are making an offer to buy that item. You are making the offer to buy. You're the one making the offer, not the supermarket, not the cashier. You are the one making the offer to buy. So everything until that is what? An invitation to treat. So, Chaminda, your example of this leaflet that is put, that is an invitation to treat. That is to get you to come to the supermarket.
Correct.
It's a advertising mechanism to get you to come to the supermarket.
Correct.
You know, in stores, they put sale, 50% off. You can't go inside and demand something for 50% off. You can say, look, I came to the store, now can I have this at 50% off? You're making the offer. You're asking, can I have it at 50% off? The shop can say, no, this item is not 50% off. We can't give you a 50% discount. The banner on the door saying sale 50% is not an offer. It's an invitation to treat.
Right, yeah.
Right? So there's a case. Pharmaceutical Society of Great Britain versus Boots. Pharmaceutical Society of Great Britain versus Boots. Now, this is a case that involved the Pharmaceutical Society in England and Boots pharmacies. If you've been to England, you have seen Boots Pharmacies, which is a big pharmaceutical chain, right, that exists in England. Now, Boots pharmacies look like what we see supermarkets look like. You go into the supermarket, like the pharmacy, you walk along the aisles and you pick up the items you want and you go to the cashier. Right? Now, the Pharmaceutical Society said there is a requirement that a sale cannot be made of pharmaceutical items without a pharmacist present. Pharmacist must be there when a sale is made. Pharmaceutical Society said, so when the items are on the shelf and the person picks it up and puts it in their basket, a contract is made. Items on the shelf are the offer. Me putting it in the basket is acceptance. There is a agreement. A sale has been made. That's what the Pharmaceutical Society said. Booth said, no. There is no sale made there. The sale happens at what point? The sale happens at the cashier. When the customer goes and gives that pharmaceutical item to the cashier, he makes an offer, and when the cashier rings it up, bills it, that's the acceptance. That's where the contract is created. The contract is created at the cashier when you make the offer and the cashier accepts. It's not at the aisle. Right? And Boots proved that every one of their cashiers were who? Pharmacists.
Pharmacist.
They were pharmacists. So a pharmacist was present when the contract was entered into. So Boots was able to prove that there was no violation. They didn't violate the law because the offer. So in this case, right, an offer was made. That offer was made. So when the offer is made, it makes a very big difference. Okay. So similarly, another case, Fisher versus Bell. These are fascinating cases because these are situations you and I deal with on a daily basis. Right?
So, sorry, sir.
Yeah, go ahead.
There the offer is made, but the acceptance was not done, right?
Yeah.
In the pharmacist case.
No, the acceptance happens when the pharmacist bills it.
Yes, but it was not done. So acceptance is not there.
No, acceptance is there, Sahir, at the cashier. Right?
Correct.
At the cashier, there is acceptance, and at that moment, acceptance being there is not a problem. Why? Because a pharmacist is there. The Pharmaceutical Society's complaint was you can't enter into a contract without a pharmacist there.
Yeah.
So the pharmaceutical item was sold only when the pharmacist was there at the cashier. So acceptance happens there, offer happens at the cashier. Okay. Another case is Fisher versus Bell. Now in England, at a long time ago, it was illegal to offer. So it was a criminal offense to offer to sell pocket knives. Nobody could offer to sell pocket knives. Okay. So this shop owner had pocket knives displayed on his shop window with a price attached to it. Okay? So the authorities came and sued him. For what? For offering to sell pocket knives. They said, look, by putting it on the shop window for sale with a price tag, you're offering it to sell. The courts held that it was not an offer. It was only an invitation to treat.
Great.
The offer was made when? When the customer went into the shop and to ask the shopkeeper, can I buy that knife for £50? When he asks that question, then the customer is the one making the offer. Most of these times, the customer is the one that is making an offer. You go to a bakery or a pastry shop, and there are items displayed on the counter. You go and say, can I have one roll, one patty, one malupang, right? Okay. When you say those things, you are making an offer to buy those items at the displayed amount. Then the shopkeeper has the ability of saying yes or no. Do you follow that?
We do follow.
All right, perfect. So we have to make sure that an offer is different from an invitation to trade. So now let's talk about the digital world where we make make offers and sell things all the time on Facebook Marketplace and all these other platforms, right? Like digital sales are a lot of Amazon. You go on Amazon, you add to your cart, and you check out. So is Amazon offering to sell something when they display it on their website?
Invitation to trade.
No.
It's an invitation to trade. So at any moment when you click checkout, they can reject that and say, we can't, this item is not available, we can't sell it to you. Because if not, the moment you say add to cart, a contract has been created. If the advertisement is the offer, you putting it in your cart is acceptance. Then there's a contract. Then it would be a breach of contract for Amazon to change their mind. It would be a breach of contract for you to take it out of your cart. Right? Because you already bought it. But no, the Amazon web page is only a invitation to trade. You put it in the basket and go to checkout. That is when you are making the offer. When Amazon accepts that and proceeds with your payment, that's when the acceptance happens.
After payment completion only, contract is formed. Like
correct. When you proceed to checkout, you are making the offer to buy these items. Then when Amazon processes that, when they say payment is done and your order is placed, that is when the acceptance happens. Yeah.
So offerer will be the customer.
And the whole process is correct.
Offerer will be the customer, offeree will be the
seller. Yeah, this is not always the case, Rangaji. You have to understand there is no rule that says the customer is always the person making the offer. That is not always the case, right? Sometimes the seller makes the offer. Seller outright makes the offer, right? We'll talk about a few cases where sellers have made offers.
Like giving discount.
Giving discount is not necessarily an offer, but there are instances where sellers have offered to sell, right? Do you want to buy this item? I can ask you. Do you want to buy this item? So then I'm making an offer. I'm the seller in that instance. I'm making an offer. But what we're trying to say is that the law calls it advertising puff.
Yeah.
Right? Advertising material often doesn't amount to an offer.
Yeah, that is the concept.
Advertising material is just to get you in through the door. Sandima's example is the best example, right? It's the leaflets that they put on your car window, put it under your door. All those leaflets are a way to get you in through the door. Right? Now, that's why these banners will say about, yeah, sorry, go ahead, Chandni.
What about if somebody walks into your house to sell something?
Yeah, so
Now
he's made, in that instance, he is offering you he's offering to sell it to you.
okay, in
A
that case,
door-to-door
the person
salesman,
is yeah.
the door-to-door salesman comes and says, "Do you want to buy this set of steak knives?" He's making an offer. Yeah,
Thank you.
correct. So don't take it as a rule that the customer is always the one who makes the offer. There is no rule like that.
Depend on
It
situation.
depends on the situation. Very clearly, you have to understand it depends on the situation. Because even on Facebook, I can put an advertisement to sell something to you. I can say, look, I'm going to sell my car for 5 million rupees, right? The first person who accepts this offer, I will sell it. So the first person who sends a message to me saying, I'll buy it, has accepted. My Facebook message is an offer. Why? Because now I told you what an offer is. It's a very clear indication to be bound. But that's very different to me saying, I'm selling my car. Anybody who's interested, please DM me. No, that's not an offer. Just because you DM me, I don't have to sell you my car. But if I say I'm selling my car for 5 million, the first person who replies to me, I will sell it to them. Right? Then I'm making an offer. So it all depends on the words that are used and how it is used. The context is very important. Clear? Okay. So we must distinguish an offer from an invitation to treat. An offer must be a very clear intention to enter into a contract. Clear intention to enter into a contract. Now let's say for a minute that an offer has been made, a valid offer has been made. What can happen to that valid offer? Lots of things can happen to that valid offer. Of course, the valid offer can be accepted. The offer can be accepted. That would be the best. No, those two elements coming together is what will create an agreement. Offer and acceptance coming together is what will create an agreement. Right? So the best option is for there to be acceptance. But once an offer is made, lots of things can happen to that offer. Number one, the offer can be rejected. The offer that is made can be rejected. Right? You go up to the cashier and you put the items on the checkout and say, I want to buy these items. You're making an offer. But the cashier might say, sorry, we can't sell you this item. We can't sell you this item. They have the ability to say that. So when an offer is made, one option is you can reject the offer. You can outright reject it. This rejection of an offer might even happen by way of a counter offer. Rejection can happen by way of a counter offer also. Now I come to you and I tell you, do you want to buy my smartphone, my used phone for $500? I offer to sell you my phone for $500. I offer it to you. So I have made an offer to sell you my phone. Okay? You can outright say, no, I'm not interested. Then what have you done? Rejected my offer. Or you can say, I'll give you $400. I say I'll sell you my phone for $500. You say, no, I'll buy it for $400. That is a counter offer. You are making an offer of your own. I have made an offer to sell it to you at $500. You are making an offer to buy it at $400. When you make a counter offer, the original offer is rejected. Yeah. So basically, you say, I'll buy it for $400. I say, nothing doing, forget about it. And then you say, okay. I'll pay you $500. What you initially asked. I'll say, no. Now that option is gone. Now that offer is rejected. Now I'm not selling it to you at all. So after you make a counter offer, you reject the original offer. You can't go back to the original offer. Okay.
Correct.
So very important to understand the offer can be rejected, and that rejection can happen by a counter offer as well.
Outright. Yeah.
Okay.
Correct.
Next, an offer can lapse.
Lapse.
Offers that are made can lapse. Offers that are made can lapse. Now,
Correct.
how offers can lapse through multiple ways. Number one, offer can lapse by the offeror dying. The death of the offeror. I make you an offer to sell you my car, but before you accept, I die. Then you can't go after my family to accept that offer. The offer dies with me.
Okay.
Offer lapses with death. Offer can lapse with the lapse of time also. I can make an offer to sell you my car for 5 million rupees, and I'll say that offer is only valid for 24 hours. Now, when you all do business, that is often the case too.
Correct.
Offers are made, and it said, look, this offer is only valid for 48 hours.
Yeah.
Right? So after the 48 hours, what has happened? The offer has been lapsed. It has lapsed. So you can't accept that offer thereafter. Now, even when the offer does not have a time limitation, even if the offer doesn't have a time limitation, it can lapse. Offers can lapse even when they don't have a time limitation. Right? When a reasonable amount of time is gone, so I make an offer to sell you my car today, 2 months from now, you can't accept that offer because a reasonable amount of time has lapsed and that offer has lapsed with it. Okay? So, offer can be rejected, offer can lapse. Number three, offer can be...
Offer
Yeah,
can
go ahead.
also left because sometimes, the companies advertise this price is until this date or until stock last.
Yeah, can lapse that way also. Yeah.
So
Correct.
that we also say exhaustion of item on offer. Or...
Yeah, that also is a way of lapsing. Yeah, correct. The offer lapses when the items are sold. Yeah.
Right.
But in that case, they should display the how many items are remaining.
Not necessarily. I mean, if you think that they are lying to you about how many items are remaining and they're having stocks and not selling, then that's a different way of going about it. You can go against them for that, for lying when they're having stocks and not selling it to you. But there is no requirement for them to disclose how many items are there. No, there is no requirement.
Yeah.
Yeah.
So
Sometime when we are going to book the flight, it shows how many seats are left.
Yeah.
So that kind of things it should be there, Otherwise.
Yeah, I mean, ideally it should be the case, but when these, for example, electronic stores and all that will say, this offer is valid till this day or until stocks last. Yeah.
Stock loss.
but there's no
That can
proof.
happen.
There's no
There
confirmation.
is no
until
proof.
then.
Yeah. I mean, if they're lying to you in that event, there is a way of going after them through the consumer affairs.
Yes.
Consumer Affairs Authority is there to protect consumers. So sellers can't lie to people. Sellers can't lie to people because Consumer Affairs will say, that's not allowed. So if you have a reasonable ground to believe that these guys are lying to you, they have stocks and they're not selling it now, they're holding on to it, you can make a complaint to the Consumer Affairs. They'll carry out an inquiry and penalize.
Okay.
That is an option you have. I mean, sellers do that sometimes. Sellers do say that and they hold on to certain stock because the item is popular and they say, no, stocks are over.
Especially
They're
airline.
lying to you. You can take action again.
Yeah, especially airline. When you go into the ticket, you will not find the lower class. I mean, there are classes, no? The cheap you will not find, and it's all. But the real case is it is there. They block and they not allow people to. Yeah.
Correct. Yeah. I mean, yeah. So, I mean, if that kind of scheme, you have ground to believe that they are doing that, you can always go to the consumer affairs and complain that this is happening. Okay, right. So, rejection, lapse. Third, it can be revoked. An offer can be revoked. An offer can be revoked. Meaning, I make you an offer, and before you accept the offer, I take it back. I tell you, look, do you want to buy my car for 5 million? Now you are spending a little time thinking about it. While you're thinking about it, I come back to you and I say, no, I've changed my mind. I've changed my mind. So if the only requirement for revocation is that it has to happen before acceptance. If you have accepted, I can't revoke thereafter. Revocation must happen before the acceptance of the offer. Right? Before the acceptance of the offer, you have to revoke. But you have the option of revoking. Any offer you make, you can revoke. Even if you say you're going to keep the offer open for a particular period of time, there is no reason, there is no requirement for you to keep it open. You can revoke it anytime.
Now in the case particularly in the contracts, now as I mean, since you are, I mean, deal with this construction law, you might, I mean, the law you might know. Now, when the tenderers submit their bids, so there will be a period of we will hold that tender bond till 90 days, or till appointment of the contractor. So during that 90 days, I mean, even the employer not issued his even LOI or not issued at any till the moment of LOI issued, there is a possibility to revoke the offer by the contractor, right?
So the question here is, who's making the offer? Now, in a tender, who's making the offer?
Contractor.
Contractor is making an offer to be given the bid. Yeah. So until the acceptance happens, which is when you pick that tender, until you pick that offer, the other person can revoke anytime. He can revoke. He can revoke. Taking off my.
Even the tender received.
Only issue is that you can revoke trunker. Only issue is that the client can claim the tender bond. They can in cash.
No, you cannot. No,
they can
because why client cannot? I don't know. You can correct me if I'm wrong. Why client cannot revoke? Because client not accepted him as the selected contractor. So it is.
I mean, as I understand it, that would be the case. Yeah, that you can revoke if you haven't been selected as the correct contractor, then you can revoke. But I don't know if there are any construction regulations which they say something different. But as I understand it, that is the correct position.
So there are some cases, yes. The contractor can revoke his offer before the acceptance by the employer. Having said that, I mean, it's not mean that employer received his offer. It is not acceptance. Yeah, he received the offer according to the time frame, but it is still a possibility to take back his offer.
Because there's no acceptance. So until there is acceptance, you can revoke.
Yeah.
So anytime before acceptance, you can revoke the offer. Now there are one instance where you can't revoke certain offer. That is where the other party has paid you some money to keep the offer open. That is an offer you can't revoke. I make you an offer to buy your car for make an offer to sell you my car for 5 million. Right? You pay me an advance of 50,000 to keep that offer open for 2 weeks or 2 days. Now I can't revoke my offer until that time because I have taken your money. But other than that, anytime you want, you can revoke the offer. Okay? Clear on all of that? So your
Great.
offer can be rejected, lapsed,
revoked.
So I'm getting a call from PIM. Your offer can be rejected, lapsed, revoked. And finally, your offer can be accepted. The offer can be accepted. Yeah? Now, for an offer to be accepted, there must be a valid, so for there to be acceptance, there must be a valid, so we are moving on to the requirement of acceptance. Now, this is still under that second point. I'm still talking about this agreement. For there, so we talked about domestic agreements and commercial agreements. Then we are now talking about offer and acceptance. So offer we have now covered. Once an offer is made, what happens? Rejection, lapse, revoke, we've talked about. An offer once clearly made can be accepted. For acceptance, there must be a valid offer. And the acceptance must be absolute and unqualified. Absolute and unqualified. Meaning, your acceptance must not be with conditions. Your acceptance must be unconditional. Let's say I offer to sell you something for 300 pounds or $300. Okay? I offer to sell you something for $300. You come back to me and I say, I accept your offer. I will pay you $150 now and the remaining $150 in 3 installments of $50 each. Now you have accepted my offer. I offered to sell you something for $300. You come back to me and I say, yes, I accept your offer. I'll pay you $150 now and the remaining $150 in 3 installments of $50. That acceptance is not valid. Because your acceptance is not unqualified and unconditional and absolute. You are making a conditional acceptance. A conditional acceptance is what then? What would it amount to?
Counteroffer?
Counteroffer, absolutely right. It is a counteroffer. When I offer to sell you something for $300 and you come back to me and I say, I accept, I'll pay you $150 now and 50 in the other $150 in 3 installments of $50 each. What are you saying? You are making an offer to buy something from me for $150 upfront, $50 installments thereafter. Then I can accept or not. It's not acceptance. So, and a valid acceptance must be absolute and unqualified. Is that clear? Absolute and unqualified.
Unqualified.
Yeah. And of course, acceptance must be communicated. You have to use your words and accept the communication. You have to communicate your acceptance. So a couple of things to know about acceptance beyond that. So for acceptance, there are 3 requirements. 1, there must be a valid offer. Number 2, it must be absolute and unqualified. And number 3, it must be communicated. The acceptance must be communicated. Okay? Very simple requirements. Everybody's with me?
Yes, yes.
Yep. Okay. Now, one thing is silence cannot amount to acceptance. Silence doesn't amount to acceptance. Usually in law, silence can amount to a lot of things. But in acceptance, silence won't work. So in a case called Feldhaus versus Brindley, what happened was this uncle offered to sell his donkey or horse to his nephew. He wrote a letter to the nephew saying, nephew, I want to sell you my donkey for $50. And if I hear nothing from you, I will consider it acceptance. And the nephew didn't write back. There was no communication from the nephew. The uncle considered that to be acceptance. Court said no. Acceptance cannot be by silence. Silence cannot amount to acceptance. Okay? Now, sometimes when you make the offer, you might also say how the acceptance has to be communicated. You sometimes say, please send your acceptance by way of an email. So then accepting by a phone call is not valid. Why? You have to accept using that method that was specified. Okay. Now let's say there is no method stipulated. I make a call, I give you a call and I make you an offer. I make you an offer to sell you something for $200. I don't specify a method of how to accept. The law is that you have to then accept in a method that is as equally fast as the method in which the offer was made. So that means I made the offer via telephone call. So acceptance would have to be a telephone call or a method that is faster than a telephone call. You can't send me a letter accepting. You can't use a slower method to accept. Now, but if the offer was made by way of a letter, you can also accept by way of a letter. Do you follow my logic? This logic makes sense to you? Yeah.
It does make.
If the offeror says, I want you to accept in this way, send me an email to accept. If you accept, send me an email, then you have to send acceptance in that method. If I don't specify the method on how to accept, you have to accept in a method that is equally or faster than the method the offer was made. Are we okay on this?
Yes.
Okay.
That means offer received way or more than faster than
or the way the offer was received or method faster than that.
Faster than.
Correct, yes. So if you receive the offer by way of, now back in the day, sometimes the offers are made by way of, a letter sent by way of horse carriage. And in the letter, offer says, send me your response in the return carriage. So with the returning carriage, send me your acceptance. If you don't send it in that way, finish. You get what I'm saying? So if an offer is made by way of a letter, you can accept by way of a letter, a telephone call, an email, whatever way you want. Because they're all faster than a letter. Okay? Now, here's where things get a little more interesting. Now, let's say this scenario happened. Now, just I'll give you a little breather after this, okay? Let's take this scenario. On the 1st of this is May, 1st of June, tomorrow. 1st of June, I make you an offer. Okay, let's, for the sake of this argument, assume that offer was made by way of a letter, a snail mail. Back in the day, it was mostly snail mail, so all these rules are based on those old laws, right? Old methods. I send you a letter offering to sell you my house. Okay, I send you a letter on the 1st of June. Remember the timeline, huh? Okay. On the 5th of June, you receive this letter. 1st of June, I post the letter. 5th of June, you receive the letter. On the 7th of June, on the 10th of June, you write a letter to me saying you accept my offer. Okay? You post it on the 10th of June. I receive your letter on the 15th of June. 1st of June, I send you a letter. 5th of June, you receive the letter. 10th of June, you accept the letter, accept the offer. The 15th of June, I receive the acceptance. Okay? But on the 12th of June, in between the 10th and the 15th, on the 12th of June, I have sent you another letter revoking my offer. Remember, revocation. Revocation must happen before acceptance, no?
Yeah.
Right? Now, when did I receive the acceptance? On the 15th. When did you post the acceptance? On the 10th. When did I revoke? On the 12th. Now, my question to you is the revocation valid or not?
Valid.
Not valid.
Revocation is valid?
Valid.
Not valid?
Not valid.
It is valid.
Not valid? Okay.
That was posted to a 10th posted. Absolutely.
Yeah, so there is a rule in contract law called the postal rule. The postal rule, this rule only applies to accepting an offer. It doesn't apply to any other situation. But the postal rule says that acceptance happens the moment you post the letter, not when I receive the letter. The moment you post the letter. So when did you post the letter? 10th.
10th.
So therefore, my counter or my revocation on the 12th is valid or not? It's not.
Invalid.
I can't revoke. I can't revoke. Postal rule. It's a very, very famous rule in law. Now, you might be wondering, why am I telling you all of this? Because we don't communicate by way of post anymore, right? But we have similar rules with regard to email communications.
Yes.
Right? Now, when an email is sent to you, right? When is the email received? When does the law consider the acceptance to have happened? It considers the acceptance to have happened the moment that email hits your inbox. It doesn't matter when you read it. You don't have to read it today. But if the email is received in your inbox on a particular date at a particular time, now we are not talking about days, it's sometimes hours, minutes, right? If you receive the email at 8:30 a.m., that is acceptance.
Though he not seen the email.
Though you have not read the email, though you have not opened your email account, the moment it reaches your inbox is the moment that acceptance happens.
What if you go to the junk folder?
That's a good question. I genuinely don't know the exact answer, how the courts would decide that, because it will have to be decided by a court one day. But one would assume that it's still the date that it came into the folder. Because
but still it is in his email, no? Even it is.
Yeah, that's the thing. It came into your email, but the rule generally applies to when it comes to your inbox. So the argument is, what if it accidentally goes into your junk mail?
Junk mail. I mean, instruction from IT is to anything in the junk mail not to even open.
Yeah, correct. That is the thing. So this is something that will have to be looked at. We don't really know. But then there's always the possibility, that if you look at it in the day, right? Correct. Just because the letter is posted, there is no guarantee I will receive the letter. It can get lost. It can get lost. That's similar to the junk folder. Usually you have an analogy to the digital world in the olden law.
Old world, yeah.
Right? Just because the letter got lost doesn't mean there is no acceptance. The moment it was posted, there was acceptance.
But in the email itself, it's clearly defined the inbox, right? So it's
inbox, yeah. Yeah, I mean, so the fact that what they mean by inboxes is that comes to your email. Whether it comes to your junk folder or not is irrelevant, is the argument that it would depend. two lawyers, me and some other lawyer, will have to one day argue it in court, and somebody, the judge, will have to make a decision. But my argument is, junk folder is similar to a letter getting lost in the post office. Doesn't make a difference.
Correct.
Acceptance happens the moment it hits the inbox. Acceptance happens the moment it is posted. You could make an argument. But it's a great question, Jaminda. I unfortunately do not have a perfect answer for you. Right? Okay. Why don't we take a small 10 minutes, 15 minutes? You know?
Yeah.
10 minutes?
Yeah, it's okay.
10 minutes should do.
10 minutes?
Yeah,
Okay.
10 minutes. Sir.
We'll reconvene in 10 minutes.
Yeah,
Yeah.
sure.
All right. Perfect.
Good.
Come here. Mm. Mm. Nice. Come, come. Huh?
Shall we start or will we be back? Took a little break. Good. Is everybody back?
I think yes.
Okay, I think we can start. Okay, so far we have talked about this idea of an agreement. When is there an agreement that is legally binding? One, we talked about when it is legally binding because domestic agreements are not legally binding. Commercial agreements are legally binding. Then we talked about what an offer is, how to distinguish it from an invitation to treat, what happens once an offer is made, can be rejected, lapsed, revoked, and accepted. And finally, we talked about acceptance, right? Now, there's a famous case that talks about acceptance and offer and how can it be accepted, when is acceptance there, all that. And so this case dealt with whether there's an offer, whether it's an invitation to treat, whether it's acceptance, all of these factors were discussed in the case of Carlyle versus Carbolic's Smoke Ball Company. Famous judgment, right? So what happened in Carlyle versus Carbolic Smoke Ball Company was So this was in England. There was a massive influenza, right? An epidemic, a pandemic that was going on at the time. So this company called Carlyle Smoke Balls apparently came up with a cure for it, right? They came up with a way of preventing you from getting influenza. So they put out an advertisement on the newspaper saying that if you take our smoke balls, it was the product was called a smoke ball. If you inhale and take our smoke balls, we can guarantee that you will not get influenza. And if you happen to get influenza after smoking the smoke ball, we will give you a reward of £100. Just to show how serious we are going to deposit £1,000 in an escrow account. Okay, this is all there in the newspaper. Newspaper article was put that if you take our smoke balls and you still get influenza, we will give you a £100 reward. So Mrs. Carlyle went and bought these smoke balls, and she consumed the smoke ball, and she still got influenza. Once she got influenza, she went and asked the company for her reward. they refused to grant her the reward on the basis that there is no contract between her and the company. Okay. Now we have some interesting questions that arise from this. Number one, is this an invitation to treat that was there on the newspaper, or was it an offer?
Offer.
Yes.
It was an offer?
Yes.
Why is that? Can I know why you all think it's an offer? Why is it an offer and not an invitation to treat? Anybody got any thoughts?
Because the
That's a
company
clear
even
intention.
went as far as depositing the money to a account, the money got in note.
Okay. Anybody, any other thoughts? That's a very good answer, Chaminda.
Clear intention is there.
Clear intention is there. Yeah, and that intention is seen by the fact, as Chaminda said, what? By the fact that they put money in the account.
Correct.
It was no longer an invitation to treat. It was a very clear offer that they had made. So the courts held that this was an offer. Number two,
Clear consideration.
is there acceptance? Did Mrs. Carlyle accept the offer? Because she never, now if you remember the requirements for acceptance, what is one of the requirements? It has to be communicated.
But buying the products, he accept that.
Yeah, so so the thing is this, the requirement of acceptance usually is that it has to be communicated to the offeror. Just because you buy the items from the shop doesn't mean that Carlyle Smokeball Company finds out that you have accepted the offer. No? There's no communication of an offer. No? Right? But the courts held that in this instance, acceptance happened by the purchase and using of the smoke ball. That is what gave effect to acceptance. They recognize something called a unilateral offer. An offer that can be accepted by simply complying with its requirements. A famous judgment. It changed the face of how contract law was looked at. These cases that I'm talking about are hugely popular cases. Everybody has Vikram Veerasurya's book on business law, right?
Yeah.
We all have.
If you go through, if you go through that book, there'll be about 150 cases on what we have just talked about only. Right? This little bit that we have talked about, there'll be so many cases. But the cases I'm talking about are the most famous judgments, the ones that if you ask any lawyer, they will know this case. It's so popular. Okay? So we have now done 2 points. Number one, we have defined what a contract is. Number two, we have talked about what amounts to an agreement. An agreement it's legally binding in that it's not domestic, it's commercial, and it has an offer and acceptance. Okay? Third requirement, third point in our discussion of contracts is consideration. Consideration. Now, if offer and acceptance are the building blocks of a contract, consideration is the glue that puts it together. It's a cement that holds the two bricks together. If offer and acceptance are these two major pillars that you need to have in a contract, consideration is the cement that holds those two things together. Consideration says that there must be something of value that passes between the parties. That something of value can be money or money's worth. It doesn't have to be money. Something worthy of money is also good enough. Right? So basically, if it's a sale of goods where I am buying some goods from you, I give you money and you give me a product. That's consideration. What did you get? You got money. What did I get? I got a product. Similarly, if it's a service, I pay for it, I give money, you provide a service. Now PIM pays me money for delivering these lectures. So what's the consideration? My consideration is delivering the lecture. Money is worth. What is the consideration PM is providing? Money. So money or money is worth must be there. The only requirement with consideration is it cannot be future consideration or past consideration. Consideration cannot be, I'll do something for you later. Consideration cannot be that. It cannot be, I'll do something for you later. That is not consideration. Consideration has to be present. Right? Or promising to do something 2 weeks from now is not consideration. Past consideration is also not valid. That is what? Yesterday I bought you lunch, so now today you do this for me. It's not valid consideration. Consideration must be current, present consideration. It cannot be past consideration or future consideration. And here is where Roman Dutch law comes in. Roman Dutch law says that consideration can even be causa, cause. Any cause can be a consideration. It doesn't have to be money or money's worth. It can be a cause also. So basically, in addition to these two requirements of offer and acceptance, there must be something of value that passes between the parties. You must be offering to provide something of value. They must be offering to provide something of value. If there is no requirements of value passing between the two parties, then there is no consideration and there will be no contract.
Can you please elaborate a little bit on this fact that the consideration can be also cost? Maybe one example?
Yes, of course. So one example of this was a case called Lipton versus Buchanan. In Lipton versus Buchanan, what happened was Lipton had Lipton wanted to sue someone for product liability or something like the other. They promised this other party that they will not they will not claim damages from this person until he has exhausted all other options. Take about, for example, like this, where I tell you, let's say you and I meet with a car accident.
Right.
I mean, we meet with a car accident. I know you, you know me, and I tell you, look, don't worry. I won't claim this money from you. Right? I will try every other option. I'll try to claim it from my insurance. I'll try every other way I have of claiming this money before I claim it from you.
Yeah.
That is a valid cause. So my promise to exhaust all other options before coming to you is a valid cause.
Right.
So the money is so it also has a monetary value, but we don't see a monetary value there. What I am providing is I'm providing a promise that I will not sue you until I have exhausted all other options. That's what happened in Lipton also. That's a valid cause. Yeah?
Yes.
Okay. So that's 3 requirements. Definition, agreement, consideration. 4th requirement is form. Form. What is the form that a contract must take? Now, can anybody tell me what is the form that a contract must take? Does the contract have to be in writing? What is the form? What form does it have to follow a particular model? Now you all enter into contracts for your business purposes, for on your day-to-day lives all the time. Contracts, do they have to have a particular format? Do they have to follow a form?
In business contracts, we are under the assumption that it always has to be written.
Okay.
Explicit, but not very sure based on what we now start learning from this exercise. But our understanding generally is that a business contract has to be in writing, in black and white.
In writing. Okay. All right. Anything else? Any other requirements you think that there are for a contract? other than for it to be in writing. That's one assumption that a lot of people have is contracts need to be in writing.
Some should be, some may be verbal also, sometimes.
Verbal contract also.
Yeah.
Verbal contracts can also be there. Okay.
By conduct also.
Display. And we assume that contracts need to have signatories.
Yep. We assume that contracts need to have signatories. Yep. Yeah. And it has to be signed.
Yep.
Yeah, and some people also think that contracts need to have attesting witnesses or not attesting witnesses to the contract. So some companies have the practice that contract, two parties have to sign, and there must be two witnesses also. So these are all formats, forms that you have to say. First thing is, contracts don't need to be in any form. It can be in writing, it can be orally, it can be completely orally, no problem. Why? Because when you go to your local shop and buy a loaf of bread, there is no written contract. But is there a contract? Yes, there is. 100% there is a contract. Why? Because there is an offer made, there is acceptance, and there is consideration. There's an offer. There is no written document. There is no signature. There are no witnesses, nothing. But there is a valid contract. Same requirements of a contract, same obligations of a contract are there. Now in Sri Lanka, when you get into a bus and you get a bus ticket, that is a contract. Contracts do not need to be in writing. This is a big, big mistake that a lot of people have. A misconception, like as Chamin said, there is this assumption that business contracts need to be in writing. There is no requirement. But of course, it's healthier, it's safer to have them in writing. So your legal teams in your companies will say it has to be in black and white. It has to be in writing. That's because it's better to have it in writing. Because if you have it in writing, it can't be he said, she said, no. There won't be a dispute as to what the contract is. Because it's in black and white, it's written down. Now, when you go and buy a loaf of bread on the shop, if there's a disagreement on something, right? It's your word against the shopkeeper's word. The shopkeeper will say, no, this is not what I saw. I thought he was asking for, a full loaf of bread, not a half a loaf of bread. So I sold him this, and then you're saying, no, I paid for this for a full loaf of bread, not a half loaf of bread, or some crap like that. It's between the two parties. It's whatever you said versus the other person said.
Correct.
Right? But if it's in writing, there is no problem like that. There is no issue like that because it's black and white. Everybody knows what the terms are. But there is no requirement that any contract needs to be in writing. Any contract can be even orally done. And there is also no requirement that a contract needs to be signed. But there are some instances where the law interferes and says that some contracts need to be in particular formats. There are some specific contracts that have to be in particular formats. The best example in Sri Lanka is the Prevention of Frauds Ordinance of 1840. Right? The Prevention of Frauds Ordinance in 1840 says that a sale of a land must be in writing. So, if you are entering into a contract to sell a land, now there is a requirement that it must be in writing. It must be signed. And in fact, it must have two witnesses. There is a requirement by the law. The law sets it. Right? This is, when I say the law, it is by statute. Everybody is familiar with statutes, right? Statutes or acts of parliament are acts passed by parliament, where the parliament creates law. Parliament creates law for us. And in those laws, they might say that some different types of contracts have to be in writing, have to follow a particular format. They will say that. That kind of contract needs to follow that format. But other than that, there is no requirement. Usually, contracts don't have a format. Okay? So that's number 4. And number 5 is privity and capacity. Privity and capacity. Privity talks about who has the obligations under a contract. Capacity talks about who has the right to enter into a contract or not. Let's talk about privity. Privity says that only the parties to the contract can be sued on the basis of that contract. Let's say party A enters into a contract with party B. Then the only people who can be sued on the basis of that contract is party A and party B. Party A can sue party B and party B can sue party A. That's it. Third party, party C, can't sue party A or B on the basis of that contract. Privity says that only the people who are part of that contract have any rights to sue under that contract, obligations under that contract.
So within the party.
Within the parties. Now, let's say, for example, I am a manufacturer of some product and I give it to you to sell. You're my distributor. Okay? Now, you then sell it to another small-time retailer. Okay? You sell it to a retailer. And that retailer then sells it, let's say, beyond the market value of, more than the maximum retail price or something that I'm not very happy about as a manufacturer. Okay? I can't sue the retailer. I have no action against the retailer. My relationship is with who? Only the distributor. Wholesaler. And the wholesaler's relationship is with the retailer. So I have no right to go against the retailer directly because I don't have a contractual relationship with him. So privity says only the parties to the contract will have the right to sue or be sued under that contract. Look, the thing with law is nothing is when I say rules in law, they are not black and white. There are always exceptions to these rules. Rules are like that. Nothing is 100% applicable. There's always an exception to the rule, right? One such exception is when contracts are made which are for the benefit of somebody else. Between two parties, they enter into a contract which is for the benefit of another person. Let's say Manchester United Football Club enters into a contract with, who was that player at the time? Wayne Rooney's father. Wayne Rooney was a child at that time. He was 16 years old or something when he signed up. He was a child. He can't enter into the contract. So the Manchester United enters into a contract with the father. So who has the privity to the contract? The father of Wayne Rooney and Manchester United. But because that contract was for the benefit of Wayne Rooney has a right to sue on the basis of that contract.
So Manchester United also has the right to sue Wayne Rooney in reverse.
Yeah, correct. It could be argued that they can sue Wayne Rooney also, and more importantly, Wayne Rooney can have rights and obligations on the basis of that contract. Okay. Yeah. Privity. So, but the general rule is only the parties to the contract are bound. So this is where things become interesting when we talk about tort law. I'll give you a little taste of it for you to think about before we start our session next week, right? Think about this situation and come next Friday, not today, not tomorrow, right? Let's say you and your friend go to a shop. Let's say you and your friend go to a shop. It's a normal shop, and you go to the cashier and buy 2 soft drinks, one for yourself, one for your friend. Okay? Yeah. You come back and you give your friend the soft drink, and you have yours. Now, if there is something wrong with your soft drink, you can sue, because you have bought it, you have a contract. But what if your friend's soft drink has something wrong? Can your friend sue the shop? Right? There's a famous example where the friend's ginger beer bottle had a dead snail inside it. Right? Now, can the friend sue?
True consumer can. No?
As a consumer, he can, is it?
No.
But as a contract, under contract, can he sue?
No.
Need to study.
There should be a
He can't
yeah.
study under contract law. He can't sue under contract law. Why? Because he's not a party to the contract. Your friend did not enter into a contract with the shop.
Yeah.
You entered into the contract with the shop.
But you bought the soft drink for the benefit of the friend, like what you explained in the previous example.
Therefore, they have the right to sue under
the previous one he signed obligate because he cannot enter into contract that room because of age. That's why his father entered into contract.
Yeah, in that instance, that was one of the reasons. Yeah, the Wayne Rooney's situation, that was why it was because he was younger. And the purchase of the bottle, I didn't have to give that bottle to my friend, no, Chaminda. I happened to give it to my friend. So there is no requirement. Then if that is the case, then anybody in the world will be able to sue on the basis of that contract. So the law will not allow that kind of situation. So
can sue the consumer.
Can sue through consumer affairs, is it? Okay.
Yeah, that's the talk about duty of care.
Imagine a situation like COVID. My friend is on lockdown.
Yeah.
And his family need food from their favorite restaurant. And they cannot go out, so I happen to be the person who go and buy the food for this family. And after eating food, the whole family gets some health issues.
Very valid question.
So
then the action is not in contract law. That's the answer.
Yeah.
You don't sue in contract law because they can't sue in contract law. Angajima is right into a certain extent. It is to do with consumer affairs now. Now it's sued under Consumer Affairs Authority. But I will cover this entire area and how they can sue when we do delicts or torts. It's a different area of law which will cover this. Right? But what you want to take from here is that a contract, the only people who can sue on the basis of a contract are the people who entered into the contract, the parties to the contract. Okay?
Privity.
Yeah. So, next is capacity. Under that same heading is capacity. You have to have the right to enter into a contract. Now, usually, natural human beings have the capacity to enter into contracts. That means you and I can enter into contracts. We have the capacity to enter into contracts. Right? No problem. Even companies have the capacity to enter into contracts. Companies are what the law calls non-natural persons. The law calls them non-natural persons. You and I are natural persons. Companies are non-natural persons, not natural persons. But both these groups of people have the right to enter into contracts. But Dr. Cabral would have talked about partnerships, right? He would have talked about partnerships. Now, partnerships, the partnership can't enter into a contract. Who can enter into the contract in a partnership? The partners can enter into a contract. The partners can enter into a contract, but the partnership itself cannot enter into a contract
because it's not a legal. It's not legal existence.
Yes. So a company is a unique exception where it can enter into a contract. So a natural person or a non-natural person can enter into a contract. But the law recognizes that there are certain groups of people in our society who do not have the capacity to enter into contract.
Like minors.
Like minors. So the first group of people is minors, right? In Sri Lanka, the act is the Age of Majority Ordinance 1865. Age of Majority Ordinance 1865, which places the age of majority at 18. So unless you are a major as far as the law is concerned, meaning you are 18 years of old or not, you cannot enter into a contract. So a contract which is entered into with a minor cannot be enforced in law because why? One party does not have the capacity to enter into contract. Right? Now, Roman Dutch law says that a minor can be asked to pay for certain necessities like housing, food, clothing, basic necessities. You can ask a minor to pay a reasonable amount. But English law says a minor can't be asked to pay for anything. Right? There you cannot enter into a contract with a minor. Okay? Number two, there is mentally unsound people who are suffering from certain mental illnesses, mentally unsound. Soisa versus Soisa says that the test is to see if they have the inability to understand the nature of the contract. Is their mental state such that they are unable to understand what they are entering into? So this is a medical requirement. You have to prove it in court. You have to come to court and show through medical evidence. A doctor has to come and say this person doesn't have the mental capacity to enter into this contract. Some people lose the mental capacity after they enter into the contract. Then the contract is valid. Because you had the capacity to enter into the contract at the time you entered into it. So if you didn't have the mental capacity at the time you are entering into the contract, then there is no capacity to enter into the contract. Such a contract will not be valid. Right? But if I knew this, what I'm entering into at the time I'm entering into it, and later on I suffered a mental breakdown or a mental illness, that doesn't affect the validity of the contract. So Soisa versus Soisa is a good case to understand mental unsound people and capacity. And thirdly, intoxicated persons. Those who are severely intoxicated may not have capacity to enter into contracts. Intoxicated does not mean a person who has had a couple of drinks, right? Intoxicated means a person who is so drunk that they do not understand the nature of the contract that they are entering in.
The time he
don't
signed
understand. Sorry?
The time he signed the contract or enter into the contract, right?
Enter into the contract, that he doesn't have the capacity to understand what he is entering into at the time he's entering into it. Like, see, there in some countries, right? Cabs will refuse to take you if you are so drunk beyond a certain level. That's because although you get into the cab, there is no capacity for that person to enter into the contract. Right? In countries like America, that is a very common thing. They refuse to take you if you're that drunk. Right? So that means that you don't have capacity to enter into the contract. So intoxicated persons who do not know the seriousness of their actions will not have the capacity to enter into contracts. So 3 groups of people, as far as the law is concerned, who doesn't have capacity to enter into contracts: minors, mentally unsound people, and intoxicated persons.
What about the drug dealers and narcotics and all those? Those are also not allowed, right?
Those are not that those people don't have capacity to enter into the contract, Rangajeev. That is correct. They have capacity. You know, a person selling drugs, if I want to buy drugs from someone, he has capacity, I have capacity, no problem. The problem is the contract is illegal. It's an illegal contract. So the last thing I want to talk about today is illegality of contracts. That's number 6.
One thing here, Dr. Cabral came up with an example during our session where he was working for Sri Lankan cricket, and somebody came to sign an agreement about telecast rights of the thing. And the cricket board was all up for signing, but Dr. Cabral objected because they never knew who's coming to sign. Okay, I think that's not rather capacity, that's authorized, correct? Whether it's
that's authorization. That is not a capacity issue.
Correct. I got a little bit mixed up.
In that instance, it is whether he has the authority to sign on behalf of the company.
Correct. Two different.
So it's not a capacity. Correct. Right. Okay. So privity and capacity is your number 5 point. Number 6 is illegality of contract or legality of contract. The contract that you enter into must be legal in the eyes of the law. You can't enter into a illegal contract. Now, what is an illegal contract will vary from country to country. Because different countries have different things that are illegal contracts.
Correct.
Like, say, for example, in Sri Lanka, selling marijuana is an illegal contract. It's illegal to sell marijuana. So, if I want to buy marijuana, somebody wants to sell me marijuana, we both have capacity. We can enter into a contract to with all the requirements satisfied, but it's illegal to do so. But if you go to Amsterdam, that contract is legal. Because selling marijuana is legal in Amsterdam. So, what is legal and illegal will vary from country to country, guys. And sometimes we have cross-border contracts which are between two different people from 2 different parts of the world. So, you have to make sure that that contract is legal in both countries. Let's say I'm entering into a contract with someone from Oman. We have to make sure that the contract is legal not only in Sri Lanka, but in Oman also. Because we don't know when the enforcement will become. Will be there. Look, that doesn't mean that people don't buy marijuana here in Sri Lanka. Right? People buy marijuana all the time. Contracts are entered into. Right? Somebody will pay, somebody will give. Contract is there, offer is there, acceptance is there, consideration is there, all the requirements are satisfied. The only problem is, if there is an issue, let's say you provide the marijuana, but the payment doesn't come. Right? You can't sue for breach of contract. You can't take that to a court of law. That's not a legally enforceable agreement. Remember, we talked about it as a definition. An agreement which is legally enforceable. An illegal agreement or illegal contract cannot be enforced in a court of law. So, what are illegal contracts? Well, contracts are made illegal sometimes by statute, sometimes by common law. Statute is by parliament, acts of parliament. Common law, I don't know if Dr. Cabral touched on this, common law is the law of the land. Usually common law is decided by judges. They are the ones who create the law. By deciding cases one after the other, by building on cases, they create what is called the common law of the country. Okay? So, there are illegal contracts by act of parliament. Like, for example, fixed prices on certain consumer goods, their maximum retail prices, they are set by statute. By statute, the Consumer Affairs Authority have the right to set a maximum retail price of any good. You can't sell this product for more than X amount. So if somebody sells the good for more than that, it is illegal. It's a illegal contract. During COVID, I don't know if you all were here and if you all heard about this. Kapruka was charging massive amounts for grocery items. For a salmon tin, they were charging exorbitant prices. They can't do that. It's an illegal contract. Right? So you can't do that. That sort of thing is not allowed. Right? So the contract can be made illegal by way of statute, by act of parliament. Sometimes the contract can be made illegal by common law. For example, a contract to commit a crime. You and I get together and enter into a contract. What is the contract? The contract is that you and I will rob a bank. I will rob the bank. You will drive the getaway car. It's a contract. And the agreement is that we will split the money that we steal 50-50. Right? There's a contract. Offer is there, acceptance is there, consideration is there, everything is fine. So you're driving the getaway car now. That's what you're providing. Now, after the getaway, if I refuse to give you the money, if you any money, you can't take that contract to the courts and say, look, I drove the getaway car, but he's not paying me my share of the money that was stolen. Right? There's a case also on this. Everett versus Williams. Everett versus Williams was exactly that. That they entered into a contract to rob a bank and split the money. That one person didn't follow through on their terms of the agreement. Nothing can be done. It's an illegal contract.
So maybe after that case is dismissed, then court might sue against both of them because of the...
Correct. If you go to court for that kind of thing, then you end up in a criminal case for robbing a bank. Yeah, 100%. Contracts to promote sexual immorality is also illegal contracts. Provide contracts to promote sexual immorality. Right? Contracts to promote corruption of public life. Bribes. Corruption of public life would be bribes. Right? Would be illegal contract. I give you a little bribe for you to do something for me. You will pick my tender and I give you a little something. That contract is not valid. It's an illegal contract. That can happen, no? I submit a bid and I give you some money saying, look, pick my bid. And now after you take that money, you don't pick my bid. I can't go to court and say, look, I gave him some money to pick my bid. He's not doing that. Right? Illegal contract. Contracts to prejudice administration of justice. If you pay someone to lie in court, give bad evidence or false evidence in court. Imagine somebody is going to give evidence against you. You give them a call and say, I'll pay you 1 million rupees if you lie on the stand. That's an illegal contract. Cannot be valid. Okay. So illegal contracts will not be enforceable in a court of law. Doesn't mean that illegal contracts don't happen never. It simply means that they are not enforceable in a court of law. Okay. What do you think? I'm just wondering. Any questions up to this point? Any thoughts on what we talked about?
From my end, no, because I always ask questions as it goes, so nothing.
Yeah, that's good. Nothing. Anything, anyone? Just wondering, 8:32. Do we do another point, or because the next one is quite long, lengthy? Maybe I won't have time to finish that. No, we'll wrap it up here. We'll call it a day today here, and then we'll pick up the rest of this tomorrow. We have the entirety of tomorrow also. So tomorrow, the plan is that I'm going to discuss the rest of contract law, and then discuss a little bit on Sale of Goods Act or the Sale of Goods Ordinance, and also discuss the Consumer Affairs Authority. Dr. Kabra likes to give a question on the Consumer Affairs Authority sometimes at the exam, so I will discuss that also. Right, so all those areas are cover and finish. So tomorrow we have a lot of important things to talk about. We have to talk about terms of a contract, which is a very lengthy and a very long bit that we have to talk about, because terms are the most important part after offer and acceptance and consideration. The terms of the contract become very important, and you all must be negotiating terms all the time. So we'll have a lengthy chat on that, right? Yeah. So any questions, any thoughts finally before we wrap up? Any comments, anything? Anybody got anything?
Sometimes called void. Contract is void when it is in some separate part.
No, void means the contract is not valid.
Valid. Okay.
Void means that it was never valid. Meaning that the contract from the moment it was created was never valid. Void. We call it null and void. Null and void means it was never valid. So if you enter into a contract, let's say a illegal contract, contract to rob a bank, the contract is null and void, meaning it was never valid. Even though it had offer and acceptance, it was never valid. So void simply means invalid from the beginning. That's what it means.
So when the contract is not in line with or complying with the legality, so it can be a null and void, right?
Yes, null and void. Yes.
Sometimes incapacity people also sign the contract, enter into contract, maybe it is void.
Yes, if a person who doesn't have capacity enters into a contract, the contract becomes null and void. Correct.
Null and void.
Now, there are instances where the contract is valid for some time and then it becomes invalid. You get what I'm saying? That is not what we're talking about. This is an instance where it becomes null and void. It becomes void from the beginning. Never valid. Okay. But now later on, we will talk about situations where the contract is valid for a long time. Then after a certain period of time, it becomes invalid.
Yeah, as you said that when the time of the signing person was good, and after that he got the problem and is mentally disordered, then it will be, and such situation will come like.
You can argue, yes, that the contract becomes invalid at that point. Yes, you can make an argument, but that not necessarily going to work, because if you entered into the contract with the proper state of mind, the contract might be binding on you.
But I'm saying that in such situation will come at the beginning it was valid, but after that due to condition, contract will not valid. Like that?
No, it might not be invalid even if you have a mental incapacity later. Let's say I go to the bank and I get a loan from the bank. Now that's a contract. I have entered into a contract with the bank. 6 months later, I have a mental illness that takes over and now I don't know what's going on. But the contract that I have with the bank is valid, which is that I have to pay the loan.
Even
now, there might be a way that I may not be required to pay that. There may be a way that I may not be able to pay it, but the contract is valid, even though that I have now capacity, the contract is still valid.
In that case, we need to do certain obligations. So if we if we want to do some certain
something's happening.
Yeah, I think
YouTube is playing. I don't know where it's playing from even. Sorry. Okay, sorry about that. I was learning how to play the guitar on YouTube these days, so it's playing one of those clips. Yeah, tell me, sorry.
No, actually, if we have some certain obligation, we need to do under contract, but we have done that those obligations. Then the contract is not further, valid, because we have delivered all the obligations and we done.
Yes, then the contract is completed. It comes to an end because it is completed. That also can happen.
Yeah,
that's valid. The contract is completely valid, and then at a certain point it is completed. It comes to an end. Yeah.
No further.
So that's yes, correct. And then we could talk about termination of the contract. At termination, we will talk about this part.
Yeah.
Excuse me, what happened if that the earlier case you said about this bank taking loan, that person becoming mental illness? In that case, bank can sue the person at that point.
Correct. Yeah, bank can sue the person, but of course, there might be a defense where he can prove that he doesn't have the ability to repay because of the mental illness, that he's not able to. But generally, the bank can sue because he was in sound mind at the time of the contract. At the time of entering into the contract, he had the proper mind.
If it's mentioned some time bound within the contract.
Yeah.
That also then when the time finish.
Time lapses, the contract ends. Yes, contract ends. So we have 1 year contracts, 2 year contracts, 5 year contracts. So after the time, it comes to an end. Yeah.
It's called termination, right? It's not null and void, right?
No. At that point, it's not null and void. It's termination. The contract terminates at that. Yeah. These last points that we're talking about is termination. It's not null and void. Yeah. Null and void is because there's no capacity or because of illegality, the contract becomes invalid.
And the other thing, the implied terms and express terms. The express terms always, within it should be mentioned within the contract. But implied terms, that bring from the legality or the laws.
Yes. Implied terms are automatically imposed by the law. Automatically brought into the.
So it's not necessary to mention within the contract. Then
you don't have to mention it between in the contract, but it will be valid. So let's say, for example, one implied term is that when you sell goods, it must match the description. If you're selling by description, online platforms sell by description, the goods must match the description. It doesn't have to be a term. It's implied. So if it doesn't match the description, you can sue on the basis of that implied term. Okay. Anyway, so implied terms, express terms, termination, all going to be covered tomorrow. Tomorrow, I'm going to cover the remaining 6 points. Will cover all of this.
And Sahir, be careful. Don't be intoxicated when you come tomorrow. Okay. Sahir, I'm cautioning him. He was very careful in listening to that part.
Because previously, no. Now the thing is, when it comes to our field, this is very important. This law side, especially that implied terms. Because the contract it says whatever the conditions we referred, it will always go into the implied. If anything's come, example, liability period, it is implied terms. It is in the law. Even it is not mentioned in the contract, by country law, it will imply like that.
Absolutely. It's a very important part of contract law. That is implied terms. We'll talk about it at length. Anything else?
That's it, I guess.
Okay. If there's nothing else, let's wrap this up. And I'll see you guys tomorrow. Same time, I think. Same tomorrow, same time.
See you.
Same time. We'll finish off contract law. All right. You too. Take care.
Thank you. Have a nice day.
You too.
Thank you so much.
Thank you, sir. Thank you.
All right. Bye.
Very interesting session.
We thought
business law very boring like that.
Initially,
Dr. Cabral's session and your session very interesting.
And it's giving, fuel to listen. Usually law is very boring. But even Dr. Cabral session,
way of talk is during lectures very attractive.
The way it conveyed, to us.
like we try to make it as simple as possible because if you wanted to, you could make it very complicated, but then you all will also find it difficult to understand and grasp it. So
then they become boring for everyone.
Absolutely. There's no point in it. You're not going to learn anything also then.
Now we got in what we are doing. We are going shopping every day. We don't know now. Now we know what's happening.
Yeah, you don't know when an offer is made and when
yes,
correct,
yes.
absolutely.
It's very simple thing, but we are not aware about these things.
Aware, yeah, most people aren't. That's the problem. Very good that you're learning it now.
Okay, sir. Thank
Okay,
you.
guys. I'll see you tomorrow then. Okay, good night.
Nice.
Bye.
Thank you, sir. Good night. Bye.
All right, good night.